So we shall. Is it on? Hi, am I audible? Am I audible? Yes. Okay. Great. So while everyone is sort of recaffeinating after a very hearty lunch, which is mandatory in these kind of conferences, we need to be recaffeinated. Let's continue with the next session, which is session 5, and it's a very interesting and timely topic by Aurelio and Joon, and it's titled "The Promises, Challenges and Perils of the Rise of Private Equity Sponsor-Led Insolvency Proceedings. Lessons from the United States, Europe, and Asia." And Tomoyo will serve as the commentator. So our two distinguished presenters here will be given 15 minutes with the usual timing, followed by 15 minutes from the commentator. So over to the presenters.
Thank you so much. It is a great pleasure and honor to have the opportunity to present a paper with my close friend and excellent scholar Aurelio, and we'll be talking about private equity. So we all know that private equity firms have become a very, very important part of corporate law, corporate governance. So it has been already written like 30, 40 years ago by Michael Jensen about what are the benefits of having a private equity control firm in terms of corporate governance and agency problem and things like that. And now we are talking that private equity sponsored firms do have important roles not only in corporate governance and corporate law, but also in insolvency situation. And this applies to not only in the United States, but we are seeing similar phenomenon in Europe and also in Asia. So we thought that it will be really, really a great point to discuss in the ACFL. So here's the numbers. In the United States, private equity firms have been involved in approximately 40% of large insolvency cases. So, for example, last year there were 35 cases where the liability at the time of filing was more than $1 billion, and out of 35, 19 firms were private equity owned or sponsored firm. And as I said, this phenomenon is not only for United States, but there are many leading cases in Europe and Asia. So as you know, one of the key goals of insolvency law is how you can deal with opportunistic behavior by debtors, by creditors, and things like that. And I think that insolvency laws of major jurisdictions have been developed to address this issue quite in an efficient way. But what we are talking about is that they didn't take care of PE firms, PE-sponsored firms. This is a new world, and sometimes private equity firms have different incentives in dealing with this situation, and we are not really sure whether the current laws and practice and things like that are really, really considering that changes. So moving to the next slides, then why there are a growing number of private equity firm-related insolvency. The first reason is, of course, the growth of the PE industry across jurisdiction. So, for example, there was we all know that there are many activities by PE firms in North America, but also in Asia, the market is growing really, really fast, even much more than in Europe. So that's the reason why, natural reason why there are many new companies who are subject to insolvency filings that are sponsored by PE firms. The second reason is that, as you are very familiar, these PE firms pursue economic interest in a certain period of time. So they need to sell the companies after 5 to 10 years, and then they are thinking about how to increase the carry interest or management fee that the PE sponsor can get. So, for example, they are using LBOs, leveraged buyout techniques, which of course involved high level of debt from the beginning. So that's the second reason. And also, as you know, during the recent decade, the environment for borrowing market has been very, very borrower friendly. So, for example, the interest rate has been very low. There's been the growth of collateralized loan obligation, and on top of that, if you look at the negative covenant of acquisition loan document is becoming lighter than before, which means that PE firms have more discrepancy in doing innovative financial restructuring when it comes to their portfolio companies. So here, as is in the slides, they are sophisticated actors. So they are really engaging in out-of-court techniques such as liability management exercise and also formal insolvency proceeding. And here, I'm sure that you can see familiar logos. So there are many U.S. companies who are controlled by private equity firms, and they got insolvent. For example, Toyota, Sears, and things like that. But you also see a team which is from from UK, and then you see HomePlus, which is the third largest retail shop in Korea that recently went to insolvency proceeding. And for Australian friends, we have Deacon Smith, who went insolvency proceeding as well. So it's a global phenomenon that we are seeing. So here are a summary of the lessons from the collapse of these PE-backed firms in the world. So first thing is that, as I said, they are usually highly leveraged, which is special features that distinguish with other type of companies that goes to the bankruptcy insolvency procedures. And they are specialists. So for example, they do a lot of value shifting transaction, which is very sophisticated, very technical, some sense. So for example, utilizing sale and leaseback arrangements is something very typical for these PE-sponsored firms. So for example, in case of HomePlus, which is from Korea, is that the company itself had a lot of shops and lands in nice places, and they sell their shops, and then they lease back, and that's how they repay back their acquisition financing from the beginning. So, and sometimes, which means that sometimes the provider of acquisition financing, they are on the same board with the management. So there's a kind of conflict of interest on that issue. And as you know, most of these companies are private companies, not public companies. Sometimes they are wholly owned by PE funds, which means that there's a lack of independent oversight by directors and things like that. So here, the shareholders and the management, they are on the same boat. So there is no ordinary monitoring functioning that works as we expect in other type of company. And also, as I said, they are using various type of strategies in distressed scenarios, such as covenant exploitation, LME, liability management exercises, and things like that. So we are seeing more of not only shareholder-creditor conflict, but also creditor-creditor conflict. So I'll pass the mic to my friend, Aurelio.
Yeah, thank you so much, Joon. So I would like to start by apologizing, first of all. I know that last year I promised not to speak about bankruptcy again. So I need to apologize because actually I've done something even worse this year, which is to bring someone else to the insolvency team. So that's why I asked Joon, I lied to him, and I said, don't worry, let's write something together. It's not about bankruptcy. It's about the rise of private markets, the rise of private equity, some of the governance issues, and then I included a few sections on bankruptcy. So it was like a Trojan horse that I included here. But I thought as a capital market expert, Joon, so I thought it would be a good way to show how amazing insolvency is. Because insolvency, as you all know, it's not really about a boring civil procedure. It's about finance, it's about corporate finance, it's about incentives. So that's why we have really seen this trend, which is the growth of private markets. And actually the growth of private equity very significantly in the past decade. And that's why when we look at what private equity firms do, they typically, as Joon has said, they use leverage buyout. And that means that by definition, the companies that they acquire will have more leverage. And by having more leverage, then there is a higher risk of insolvency. So that's one point. Second, We have now board dominated by private equity sponsors. So if they dominate these companies in the event of solvency, they also dominate these boards and these companies in the event of, in the vicinity of insolvency, but also in the zone of insolvency. Once the company is already financially distressed, but not yet subject to a formal bankruptcy process. So that's why we saw the trend mainly in the US, but the trend is coming because private equity is coming and the rise of private market is a reality everywhere. So that's why, even though we have only been able to find some high-profile cases, only limited high-profile cases in Asia and the Pacific, the UK, continental Europe, we have found some. Most of them are still mainly from the US, but our intuition is that we will be seeing more and more private equity-led insolvency proceedings in the coming years in this part of the world. So if we stop here, based on what Joon has said, it sounds that the private equity firms are doing many crazy bad things, which is basically shifting value, covenant exploitation, conflict of interest, tunneling, high leverage. And actually that reminds me to a recent article that has been published in the University of Chicago Business Law Review. It's called The Dark Side of Private Equity. And it's actually signed by an anonymous author. So apparently the real name is on file with the University of Chicago Business Law Review, but the author identifies himself or herself as a person who is a partner at a leading law firm and also an adjunct professor in a leading law school in the United States, which is a bit crazy. But basically what that person said is, I've seen many crazy things that the private equity sponsors are doing. So that's why we should be careful. And actually that's somehow the message that you get if you read our paper until the point that Joon has mentioned. But the good thing is that private equity, as Joon has said, they bring also many benefits. And this is something that Michael Jensen already said in the late 80s. He said, and actually he was somehow envisioning what is happening right now, which is that public markets are no longer efficient. So the board is going to be inefficiently managed in public companies. So he was envisioning a world led by private equity and private markets, which is going to be run more efficiently. So he would probably be very happy with that. So the question is, well, what happens in times of financial distress? So we are not really questioning, whether private equity is good or bad. In general, for society, there is a bunch of literature and people definitely more qualified than us. So for example, in the paper, we have cited Steve Kaplan, for example, one of the leading authors on private equity. Many other financial economists from the US have been documented that. So we are just interested based on these high-profile cases and also what the empirical literature, the limited empirical literature on insolvency and private equity has shown. So we are trying to draw some lessons and to discuss whether the current insolvency frameworks around the world are somehow equipped to deal with this new trend in corporate finance and private markets, which is the rise of private equity. So if we look at, for example, this fascinating study by Professor Edith Hotchkiss and a few other financial economists in the US, they show that actually private equity do a good job in time of financial distress. Why? Because first of all, they deal with distress in a more efficient, cost-effective manner. Why? Because they use out-of-court restructuring and they use pre-packaged reorganizations more than non-backed private equity firms. So that's a good thing. So because we can save significant costs associated with bankruptcy proceeding. Second benefit is the speed of the resolution. Again, they document that private equity firms, companies backed by private equity, in general can resolve financial distress quicker. And also in terms of survival rate. So that is also in this study showing that on average, companies backed by private equity firms reach reorganization agreement at a much higher pace than non-private equity backed firms. So then that is somehow related to some of the associated benefits that private equity firms bring. One of them is access to liquidity. So they mentioned that as a potential benefit. Second is expertise. So when we think about the traditional control firm, we think about family-owned enterprises, for example. These families don't bring restructuring expertise because probably they went through a restructuring process once and they don't want to see the process anymore. But with private equity firms, it's totally different. They are repeat players, so they are dealing with that on a regular basis, so that's why they have that expertise. And at the same time, and this is very interesting, also they have a lot of bargaining power, and this is incredibly interesting because in the US, a very basic rule in bankruptcy is the absolute priority rule, meaning that the shareholders are going to be automatically wiped out in bankruptcy. They cannot get anything, even the ownership of the company, unless all the creditors have been paid in full. But interestingly, companies controlled by private equity firms, they end up the bankruptcy process with some equity in the firm. So what are the risks and challenges? Because these are all the benefits. So based on the anecdotal evidence that we got from all of these high-profile cases, plus the limited empirical evidence, we have found that the most kind of intensified risks typically happen prior to the commencement of bankruptcy proceedings. So in the so-called zone of insolvency. And by zone of insolvency, I mean in the context of financially distressed firm, factually insolvent firms already, but not yet subject to bankruptcy. Why? Because they engage in liability management exercise. So for those of you who are not familiar with that term, that's a fancy term that the restructuring community in the US are currently saying for out-of-court restructuring, but typically screwing some of your creditors. Because it used to be called creditor-on-creditor violence, to reflect the fact that sometimes you are restructuring and you are obtaining financing at the expense of basically postponing the payment to other creditors. So that's why there is really a fight among creditors. And this is something that, for example, Ken Ayotte, Jared Elias, and more recently Mark Rowe, for example, have documented. Also, Vince Bucola, that has been writing significantly about this, shows that these private equity firms sometimes delay filing for bankruptcy. They file too late. And why is that? Because typically they engage in these liability management exercises. And what Mark Rowe has documented recently is that these liability management exercises supposed to deal with the financial distress, but he shows that in more than 50% of the cases, the company became insolvent again 1 year after engaging in this liability management exercise. Also, they engage in what the literature call gambling for resurrection, sometimes pursuing projects with a negative net present value, but in case of success, that can be good for the shareholders. Then increase litigation and transaction, because of course, many of these transactions are going to be then reviewed during the bankruptcy process, because they often took place in the zone of insolvency. So that's why sometimes the trustee may want to use the avoidant powers to try to avoid some of those transactions, or to try to see that any breach of fiduciary duties. We have found, and I'm concluding, ready, so we have found some international divergences in the way private equity firms behave around the world. One of them is that in Korea, interestingly, the private equity firm that was behind HomePlus was criticized for filing for bankruptcy too early. But actually, first of all, that's not a problem. That's a good thing. But of course, we are coming from a region where filing too early is strange. In fact, some countries, and my apologies to my friends from India, so India requires actually a delayed filing because it requires default. So you need to go to the hospital, so India requires that you need to be almost dead in order to have access to the hospital. And when you knock at the door and say, help, I need surgery urgently, India says, well, let's wait because I need to review whether you are indeed dying or not. On average, it takes between 3 to 6 months to review whether you are dying or not, and then finally say, okay, yes, you are indeed dying, so you can have access to the hospital. So, but that is the case because the law has created somehow that. In Korea, companies can file, and that's totally fine. And if there is any opportunistic behavior, that can be handled ex post, by terminating the process ex post, by empowering creditors, of course, to terminate the process. So that's why that's not an issue. The question is, why then the delay filings in the US, and why I wouldn't call it early filing, the normal filing in Korea? Well, our explanation is because there are so many things that happen in the zone of insolvency in the US that are not allowed in the rest of the world. Why? Because as you all know here, in the US, directors' duties don't change in the zone of insolvency. So directors also need to maximize the value of the firm, so they have fiduciary duties to the company. But in the rest of the world, we have wrongful trading provision, insolvent trading provision, creditor duties, duty to file for bankruptcy. So many different rules that when the company becomes insolvent, then the managers need to do something typically to take into account the interests of the creditors. That doesn't happen in the US. Actually, after the Delaware decision in 2007, creditors can bring derivative actions, but only if the company is factually insolvent. But there is a problem with that, which is that Delaware courts have also recognized that the BJR still applies in the zone of insolvency. So then even if the director do something crazy, something that is good for the shareholder but bad for the corporation itself, even if that's in theory a breach of fiduciary duties, the courts are not going to second guess that because of the BJR. So that's why our point, and with that I conclude, is that countries in this new era of private markets and the rise of private equity-led insolvency proceedings, countries need to review the director's duties in the zone of insolvency. And in fact, we're fine with the regime in most jurisdictions. The most problematic one is the US. And we're not advocating for changing the system in the US, but very much aligned with what Jared Elias, for example, said. We said that courts maybe should play more a stricter scrutiny to the BJR in the zone of insolvency. Not to second guess business decision, we're not saying that, but at least to determine whether the directors with available information made a decision that was in the best interest of the corporation. Because if they make a decision that is investing in a project with a negative net present value, that is bad for the corporation. It's clear that they are doing that only to benefit the shareholders from the gambling for resurrection problem. Then revitalizing avoidance actions. In the US, that's also very problematic. That's why all of these obscure transactions in the zone of insolvency. Again, Jared, Elias, and many others have documented that avoidance actions don't work in the US. Why is that? Well, there are some legal obstacles, but also it's a very lengthy process. People don't have incentives, and also in the US, in a debtor in possession model, typically the managers are the ones running the firm, and they are supposed to be the ones reviewing what they themselves did in the zone of insolvency. So that's why we advocate also for empowering creditors to appoint examiners and trustees, and also maybe to consider some non-insolvency reform. So Uma Kant actually was probably one of the first corporate law scholars in the world that emphasized the need to rethink independent directors in the context of control firms in that paper in 2010. Then Lucian Bebchuk and many others have been saying that maybe we need to change the system for appointment and removal of directors. So there is a trend in private equity firms process that basically they appoint directors in the zone of insolvency to somehow bless some transaction that will shift value from the shareholders to the creditors. So this is something that Jared Elias and Kobe Castile have written about, and they are in favor of empowering creditors in bankruptcy proceedings to ratify those, what they call bankruptcy directors appointed by the private equity firm. So we are very much aligned with that view as well. And of course, in this new world, there will be more litigation and more review of all of these transactions that took place in the zone of insolvency. So that's why the judges need to be prepared for that. So my apology for exceeding my time, but thank you so much for your attention.
I think that exceeding the time can be forgiven because this is a double act, so we can suspend the rules. But now it is my great pleasure to invite the commentator for this paper, Tomoyo, to share her remarks.
Well, I think we are behind the schedule, so I just began the comment without the slides. Okay, so it's coming in time. Well, thank you very much for the very interesting paper. I enjoyed very much about on the various cases that you have digged up around the world, and it must have been a very burdensome job and analyze them, because the insolvency system is different from country to country. So I deeply thank you about that. Excuse me, is it possible to prompt the PDF?
Yeah, I've put it up for you. Do you see whether you can sort of scroll it down?
No. Okay. Thank you. So my comment is consisted of the three parts. First of all, the structure of the comment, and I briefly sum up the discussion presentation, and then put some theoretical questions, nothing new, that's some kind of very classic questions, and then share some of Japanese experience in this regard. What I want to discuss in the set of the slides is that we should balance ex ante and ex post effects of lending money from investors, and that we should consider the various legislations and regulations such as employment protection or some unwritten non-absolute priority rule applied in pre-insolvency arbitration procedure, which might take effect before insolvency law. So the first part, presentation in brief. I summarized the whole discussion very briefly, so I'm afraid I'm omitting a very important points that might be implicated in the presentation, but let me try nonetheless. The paper picked up the facts that more and more private equity funds invest or extends credit to the distressed firms, and there are more and more cases in which the firms eventually go bankrupt. The paper suggests that there are many good points, like the business, more business chances and opportunities, or rapid out-of-court insolvency process and other things. But there are also challenges and risks such as LBO, press firms deep into debt, or CLO aggravates the situation, and some various shifting transactions involving a conflict of interest factors. So, and at the end of this paper, there's a question like, does existing insolvency framework remain fit for purpose in case of where PE funds play significant role? So that means that we have to think about what kind of insolvency law reform is possible in this situation. But in very short say, I cannot understand, how we can implement the new regime for simply PE-involved cases in insolvent regimes and also insolvency law regime. So I just pose some questions. My impression when I read the paper, which might be very crude impression, but if so, I'm sorry, was that it corresponds very well to the theme presented in the classic book, Elements of Bankruptcy by Professor Bard. In that book, Professor balanced many ex-ante value and ex-post counter-values. One major controversy is the merit to directors to continue in his position versus the loss incurred by creditors by the belated insolvency process. The other one is the merit of having creditor close to directors to facilitate the business versus the loss to the other creditors when this major creditor manipulates the procedure. For example, there's a case indicated in the paper in which sponsoring PE transferred the asset in the course of 3 years. Now, ex post, I think it might appear as a well-organized long-term scheme, but ex ante, I suspect that there is still some possibility that PE was seriously trying to turn around the situation by disposing of unnecessary assets or simplifying business conglomerates. So we have to balance those two different values. And this is, in short, it is an unverifiable motivation problem, and we are facing trade-offs between regulating PEs to prevent output transactions and promoting buyouts to pursue business possibility. The second question is the question of desirability of accelerated financial restructuring negotiation. The paper suggests that reassessing directors' duties in the zone of insolvency, in enhancing the effectiveness of avoidance actions, empowering creditors, and approving greater flexibility in the design and management of insolvency proceedings, and strengthening corporate governance mechanism, especially in the relation to the related party transaction and board independence, could significantly mitigate the risks of opportunistic behavior without undermining the benefits that PE sponsors can bring to the restructuring process and society at large. There is the same argument also in Japan, alleging that directors owe fiduciary duty to creditors on the verge of insolvency, and they should avoid dubious transactions or consult their creditors. But the main problem is, when is it? If directors consult to the creditors well before insolvency, decision-making significantly slows down, which in turn might increase the possibility of insolvency. And the third question is about the possible inefficient decision by owner-creditor. The paper suggests that the creditor behave to avoid bankruptcy and prefer reorganization. If PEs are rationally judging players, they might be rationally making decisions to minimize the cost of insolvency. So if they are going private financial restructuring on the rational decision, I thought reorganization rate is rationally low, because they just decided to go reorganization by the very rational decision. But if they are delaying this process more than necessary, that means that they are not deciding the things rationally. So I wonder why that happened. This delay might mean that creditors is behaving like owner directors to avoid losing controlling power, or to conceal serious state of fund itself. So I just wonder what was the motives of this behavior. And so the next part, I shared some of the Japanese experience. I continue to some Japanese legislative experience. During the post-bubble period, many corporations go bankrupt. Avoiding the business to go stale and was the most important and urgent political concern. In this period, various new legal regimes, such as ADR or Civil Rehabilitation Act, has been introduced to enable debtor imposition and rapid financial restructuring. Once again, I can say safely that Japanese legislation prioritized the speed more than the formality. One reason is that the business going concern value dwindles very rapidly in Japan when corporations declare bankruptcy. Creditors agree on a rehabilitation plan before go to court, and the whole process is said to take about 1 month, preventing business value from deteriorating in the course of a lengthy negotiation period. The other is that it is customary in Japan that in private financial restructuring process, it is always large financial creditors that incur most losses. Credit value of transactional creditors is usually preserved, while financial debt is cut down, often more than half. Retail creditors are also relatively protected due to the tradition of main bank. So there's strong incentive for creditors also to accelerate the process. And the one thing more is that there's a strong labor law that protects the employees. And so if this means that if the business is sold at the earlier stage with going concern value, employees stick to the business. And if companies sell assets piecemeal, employees will not be relocated to the remaining, so will not be stick to this piecemeal asset. They just stay as the company and relocate it to the remaining business. That means the company cannot sell the going concern value, or they cannot cut off the employment cost. So with this legal institution background, Japanese case law allowed directors broad discretion even just before the bankruptcy or the petition of civil rehabilitation plan. Okay, so this is a very characteristic case. This is an Unizo employee buyout case. And this Unizo is a big hotel chain. And when there was a hostile takeover, the owner resisted to sell the business to those bidders. And eventually, the bidding price just shot up. And the the directors who are not courageous enough to incur the debt himself, they incurred this risk to transfer his risk to his employees, and so employee buyout took place. After that, the sale and leaseback transactions and piecemeal buying out of their assets, and then it just go bankrupt. But my observation is that the problem is not about the funds, but about the directors who stick to the control and could not finance the too high price himself. And so that is the reason why the Unizo has incurred such a deep debt. So it's an example of, there are many factors that changes the situation, and there are many people who are to be blamed even in one case. So, I just add up one additional remark. Is that there is possible intervention from the perspective of local or medical industry policy. That means that Japan has very local small corporations that needs the succession, and so they are more and more resorted to the methods of employee buyouts. And there are many small hospitals that are not going well and needs finance. So if those small corporations or hospitals just go bankrupt because they borrowed too much, then perhaps there might be a legislative or regulative intervention. But this is from outside of the insolvency law. So that means that when we want to adjust the demerit of these insolvency PE involved cases, there are many legal institutions and methods that we can use in different jurisdictions. Okay, so thank you very much. This is about what I would say.